it's a lovely day and it's a lovely church. We're in the right place doing the right thing. I'm a law professor, but what I'm going to try to do today is explain some of this in plain English. And what I'm going to try to do is be specific enough to be helpful to you about what the environmental is better. Can you hear me better? Okay. I'm going to try to be specific enough to be helpful to you to understand this, but not so specific that it sounds technical or jargony. The key thing I want you to see from this first, in terms of my presentation as a whole, if you don't remember anything else, remember that you have constitutionally protected environmental rights. You do. Your kids, your friends, if you live here, if you work here, if you have family here, we all have constitutionally protected rights. It's in Article 1, Section 27, as Randy pointed out, of the Constitution. This is the same article of the Pennsylvania Constitution that gives people the right to worship freely in this church, or any church, or not to worship at all. It's the same part of the state constitution that gives you the right to freedom of assembly, if you're so inclined, to the right to bear arms, okay? The right to all the different rights that we say we have. We have environmental rights. How unusual is this? There are exactly 4 states in the country that say that recognize environmental rights and take them seriously. Those states are Hawaii, Montana, New York, okay, and Pennsylvania. That's it. That's how unusual this is. And only 2 recognize the second part of the right, which I'll be talking about, which is a right to have the government conserve and maintain public natural resources in trust, a public trust right, as beneficiaries. That's Hawaii and Pennsylvania. So this is really unusual, and until recently, the courts did not in Pennsylvania take it seriously. So let's start with this. Randy showed you the first sentence of the amendment. Can you all read it? Is it big enough back there? Are you good? Okay. So understand this. There are really 2 parts to this. It's not written with number 1 and number 2, but there are 2 parts to this. The first sentence gives the people the rights that Randy talked about: clean air, pure water, preservation of certain values in the environment. The second and third sentences together say that the Commonwealth, which includes local governments and includes all of the state, not just the Department of Environmental Protection, not just the Department of Conservation and Natural Resources, have to conserve and maintain something called public natural resources for the benefit of present and future generations. That's the second part of this. So you really have 2 rights. You've got a right to clean air and so forth, but you also have a right as a beneficiary to have public natural resources conserved and maintained for the benefit of you as well as your descendants. So what happened in Pennsylvania after the amendment was adopted in 1971? The short answer is that the amendment was buried. And there's a lot of legal detail on this slide, but I'll give you sort of the short version. There's an old statement that hard cases make bad law. And what happened here is that the city of Wilkes-Barre had a park, and a half acre of that park was going to be moved from parkland to public street in order to make way for a street widening project. And the claim was that violated the public trust part of the amendment. Even that half acre, that extra half acre, had to be conserved and maintained as a parkland. That was basically the argument the citizens made. That gets to Commonwealth Court, and the Commonwealth Court says, well, holy smokes, okay, if that's what the Environmental Rights Amendment means, it's going to stop all development, and we can't have that. And so what they did is they substituted a 3-part balancing test that has nothing to do with the text of the Constitution, and this test became the substitute, honest to God, and I say that in a church, so it's like double underscore, I really mean it. This became the substitute for the text of the amendment for more than 4 decades. When I was a young lawyer at the Department of Environmental Resources in the 1980s, and you were writing a brief on Article 1, Section 27, the way the brief went was you quoted the text of the amendment, and then you got to the real law, which was the Payne versus Casab test. And if you look at the Payne versus Casab test, all it says is, more or less, did you comply with existing law, statutes, and regulations? Where does the Constitution fit in a test that reads like that? Okay? Where does the test fit in a test that reads like that? So what happened, a former student of mine went through and looked at all the cases under the Payne versus Casab test. The environmental side almost never won. There was even a case in this area where the Commonwealth Court used the Payne versus Casab test on a challenge to a denial of a landfill permit. And the Commonwealth Court used the Payne versus Casab test to say that the landfill permit had to be issued. Think about that for a minute. Okay? That's how the Payne versus Casab test turned everything upside down. So in 2013, of course, now we're 5 years into a recession, and we're into the shale gas boom. And shale gas is different. I mean, I know a lot of people talk about this in terms of fracking and the rest, but technically what you need to know about this is it's a different kind of drilling for gas than we've traditionally used. Traditionally, you drill a hole straight down and you find a pocket of oil or gas, done. What you do with fracking or hydrofracturing is the gas is distributed evenly within these mile-thick beds of shale, as much as a mile-thick beds of shale. And the way you get the gas out is you drill vertically down to the shale gas layer, and then you drill horizontally, and you use high-pressure explosives and water to get the gas out. Okay, high-pressure water and explosives to get the gas out. And that requires a different kind of regulation. And so in the state of Pennsylvania, the legislature passed a law to provide regulatory authority because it's a different way of doing gas drilling. What they also said was local governments don't get to decide anymore where these operations occur, where drilling occurs, where compressor stations occur, where pipelines are located and all of that. And local governments have had that authority for a long time. It's called zoning. And basically, the state legislature did away with that. In this case, the Robinson Township case, the Supreme Court said no. It's not right that local governments should lose their ability to decide that shale gas operations, for example, do not belong in residential neighborhoods, in areas that are zoned residential. 3 justices on the court, Chief Justice Castile being one of them, wrote a long opinion about Article 1, Section 27, which, again, had been buried for years, decades. And he wrote this long plurality opinion explaining in great detail how the amendment ought to be interpreted and applied. And his opinion was part of well, there was 3 justices here. There was another justice who said the law was unconstitutional for other reasons. But this was an earthquake, this 2013 decision. I live with lawyers and law students and other law people. And pretty much no one that I worked with, pretty much no lawyers, had ever really read the text of the amendment and taken it seriously. It had never happened. And in this particular case, the court said, well, this Payne versus Casab test is baloney. Plurality said, this is baloney. It has nothing to do with what the amendment is about. So it's as if, starting in 2013, Article 1, Section 27 sort of emerged full grown in the text of the Constitution. It was as if it was amended in 2013. Now, the plurality opinion, the 3 justices don't make law, 4 justices do. In the Pennsylvania Environmental Defense Foundation case in 2017, the court said, okay, we all agree this other alleged piece of legislation is unconstitutional too. We don't all agree, but a majority of us agree. And in this case, it was about leasing state forest land in particular for oil and gas. And and this is like, you go from a program that 20 years ago brought in a couple $1 million a year, a program that brings in hundreds of millions of dollars a year. And the legislature said, yeah, well, we'll take all that royalty money and we'll use it to balance the budget. And the court says, well, wait a minute. These are public natural resources. This is state land. The gas is state gas. When you convert state land and state gas to cash, that's also a public natural resource, and it's subject to the same restrictions, conserve and maintain for the benefit of present and future generations, as the resources themselves. You can't spend the money this way. The court held that. And so beginning in 2017, it wasn't just an idea, it wasn't just a plurality, it was law. They threw away the Payne versus Cassatt test, and they restored the text. Holy smokes, the text of the Constitution is actually the law of the Constitution now. Imagine that. So what does that mean in sort of somewhat more detail? The court says, well, one, if on that first sentence, I'm going back to the first sentence now, people have a right to clean air and so forth. Well, what that means, okay, is that the government cannot act contrary to that right. Okay, so you can challenge government actions that act contrary to that right. And laws that might reasonably impair that right are unconstitutional. Now, this is a right as against the government. It's not a right as against against private parties, but it's a right against the government, which is the way all these rights work. The government cannot interfere with your right to freedom of worship, for example. On the second and third sentences, the public trust part of it, the people, you, me, all of us, we're the named beneficiaries of the trust. Our children, not yet born, not yet named, are beneficiaries of this trust. And all agencies and entities of the Commonwealth have a responsibility, which means, go back to what Randy said, counties, local governments, the city of Lancaster, okay, state agencies, and others. And what are the duties of the trustee? Well, the duties of the trustee, okay, are to prohibit degradation, diminution, and depletion of these resources. That's one of the duties of the trustee. It's to preserve the body of the trust, or what lawyers would call the trust corpus. And then they go on to say the Commonwealth has to act affirmatively by legislation to protect the trust, which is quite a remarkable statement. Now, this is a lot of legal stuff. And if you're a lawyer, or if you're a paralegal, or if you like reading the legal stuff, go right ahead. I'm going to give you the non-legal version of it. You put money in the bank, okay, or you have a trust, or you have a mutual fund, or a retirement fund. The people who take care of your bank and oversee the mutual fund have what is called a fiduciary responsibility for the care of that money. They can't spend it for their own purposes. They have to maintain the integrity of that money, okay? They can't allow, by imprudent investments, the amount of money in the trust to deteriorate, okay? So imagine the public natural resources in the state being subject to the same legal responsibility, the same fiduciary responsibility as the people who maintain your bank accounts and to maintain your retirement funds and your mutual funds. Think about that. That's a big deal. That's the kind of responsibility that the Commonwealth has for these public natural resources. A new case in 2021 was wonderful. It contained this language. It said, what the Commonwealth has to do is it can't just privilege the present generation as a trustee over future generations. It has to treat present and future generations the same. So what issues does that raise for municipalities? Well, as a starting point, a lot of municipalities haven't thought very hard about any of this. Some have and some haven't. Okay? So, is your municipality acting in ways that infringe on these public rights? Okay? What public natural resources are located within the boundaries of your municipality? all right? Are they being conserved and maintained? And to go to Randy's point, all right, is zoning laws, are planning laws, or other laws being implemented and applied in ways that protect these rights? Those are questions that are worth asking. That's what Randy's letter asks local government folks to think about. With respect to climate change, I should say something about climate change at a climate change event. It's pretty clear, I think. Another lawyer and I, Bobby McKinstry, wrote a long larger article a few years ago about this, saying basically that although the language about climate change is not in the Environmental Rights Amendment, when you talk about pure water, clean air, and the preservation of the environment, that's about the climate. When you talk about public natural resources, that's about the climate. Climate change is going to adversely affect state forests, for example. It's fairly certain, I think, that the Environmental Rights Amendment covers this. If you want more, Google Widener Commonwealth Law School Section 27 resources. You may not remember the web link, but Google Widener Commonwealth Law School Section 27 resources. We have a page that lists all of this stuff. And if you want to find me, here I am. Thanks.